welcome to this explainer. Look, if you're working in the construction industry, you already know that when things go wrong on a mega project, we're talking those massive infrastructure builds, EPCs, or major commercial developments, they rarely just go wrong one at a time. It's almost always a chaotic, overlapping cascade of delays. But how on earth does a contractor actually get paid when untangling that massive web of delays feels literally impossible? Well, that's exactly what we're going to unpack today. We're breaking down one of the most complex, debated, and frankly controversial legal mechanisms in the entire industry, the global claim. All right, let's take a quick look at our roadmap for today. We'll be covering 1. The global claim concept, 2. The causation controversy, 3. Landmark rulings and principles, 4. Claimant versus respondent strategies, 5. Global perspectives and trends, and finally, 6. Some practical takeaways for your projects.
Kicking things off with Section 1, the global claim concept, aggregating the chaos.
So picture this. Your project gets hit by multiple, completely intertwined events. You've got design changes, unseasonal weather, and site access restrictions, and they all hit at the exact same time. The paper trail completely breaks down. That brings us to a really fundamental question. When exactly does a standard construction claim turn into a global claim? Normally, the law says you have to strictly link a specific delay to a specific cost, right? Event A caused cost B. But what happens when separating out those individual causes becomes a genuinely impossible task? I mean, you can't separate the weather delay from the design delay because they perfectly overlap.
Well, the answer is aggregation. A global claim is essentially a contractor throwing their hands up and pleading for a single, lumped-together sum of money. It bundles losses from multiple concurrent causes because, honestly, separating the domino effect of those delays just isn't feasible anymore. It's basically saying to the project owner, look, you caused these 5 major disruptions, and while I can't untangle exactly which dollar belongs to which disruption, the whole mess cost me X amount. And here is the math you'll usually see backing that up. It's known as a total cost claim. It's a pretty straightforward formula where the claim value simply equals the total actual cost of the project minus the original contract price. But a quick word of warning here. For this formula to hold any weight whatsoever in a dispute, you absolutely have to prove that your original contract price was actually realistic, that your final costs were reasonable, and most importantly, that only compensable events, meaning things the employer is actually responsible for, caused that massive difference. Moving right along to Section 2, the causation controversy, the rule book versus reality. Now, the Society of Construction Law does not pull any punches when it comes to this topic. Their 2017 Delay and Disruption Protocol firmly discourages global claims. Their stance is crystal clear. If you, as a contractor, maintain accurate and comprehensive records from day one, you should be fully capable of establishing a clear causal link. In their eyes, having poor contract administration or a disorganized filing cabinet is absolutely never a valid excuse to just bypass proper causal linking and slap a massive global claim on the employer. But let's be real, the official rulebook doesn't always match the muddy, chaotic reality of a construction site. Historically, courts totally agreed with the SCL's skepticism. They demanded strict proof, and if you couldn't link cause and effect perfectly, your claim was just thrown right out. However, lately, we're seeing a real shift towards a much more lenient, pragmatic approach. Courts are finally starting to acknowledge that there are genuine megaproject scenarios where establishing these individual links is practically impossible, no matter how hard the contractor tries. All right, Section 3, Landmark Rulings and Principles, setting the precedent. If you take away just one legal case from this entire explainer, make it this one, Walter Lilly and Company Limited versus Mackay from 2012. This was a total game changer for the industry. The English High Court ruled that a claimant isn't strictly obligated to prove that linking cause and effect is totally impossible, as long as the events actually causing the loss aren't their fault. It basically proved that global awards can happen. Heck, even if the contractor's own shoddy record-keeping created the mess, they can still potentially win if they successfully meet the burden of proof on the balance of probabilities. That being said, the Walter Lilly case is definitely not a free pass to just submit a messy, aggregated invoice. The strict legal principles still absolutely apply. First off, the contractor always holds the burden of proof. You also still have to satisfy all your contractual notice requirements. You know, those pesky condition precedents. If you miss the deadline to notify the employer of a delay, your global claim might be completely dead on arrival. Plus, you have to be honest and deduct any self-inflicted losses from your total. And if there are any specific costs that you can explicitly link to an event, you've got to pull those out of the global claim and process them normally. Section 4. Claimant versus respondent strategies. The battlefield. let's look at the strategic tug-of-war that happens during a dispute. On one side, contractors view the global claim as a necessary, absolute last resort. I mean, when you've got a $500 million project bogged down by 75 different design changes and totally unprecedented weather, untangling that is a nightmare. But on the flip side, you have the employer's defense. Employers frequently, and often very successfully I might add, argue that the chaos wasn't caused by their design changes at all. Instead, they'll argue it was caused by the contractor's own poor management, their labor shortages, or simply the fact that the contractor purposefully underpriced the initial bid to win the job and is now just trying to claw back their losses.
And this brings us to an incredibly dangerous reality for the claimant, the all-or-nothing risk. Because a global claim bundles absolutely everything together into one big pot, if the employer can introduce just one single, significant, uncompensable cause, let's say they prove your key subcontractor went bankrupt and delayed the critical path for a month, and you can't mathematically separate that cause from the rest of the global claim, the entire multi-million-dollar claim can just collapse. It's a remarkably high-stakes gamble. Let's zoom out a bit for Section 5, Global Perspectives and Trends, a geographical tour.
It's really fascinating to see how different regions handle these massive disputes. In the UK and Australia, courts generally accept global claims, but with a lot of caution, applying a common-sense approach like we saw in Walter Lilly. The United States, though, they take a much, much harder line. Over there, they call them total loss claims and permit them only in incredibly rare circumstances because they vastly prefer strict analytical methodologies. Meanwhile, in emerging construction hubs like Egypt and the UAE, legal experts consider the landscape to be ripe for development. Predictions suggest these civil law jurisdictions might soon become way more receptive to the global claim approach, mostly because they have fewer of those strict common law obstacles regarding causation.
And finally, Section 6, Practical Takeaways for Projects, the verdict. All right, so here is your survival guide for your next mega project. Number 1, treat global claims strictly as a last resort. They are wildly risky and super expensive to litigate. Number 2, never try to use a global claim as a rug to sweep your own poor contract administration or underbidding under. Trust me, tribunals are going to see right through that. Number 3, always manually exclude any cost you can actually link to a specific event. But above all else, and seriously, if you take nothing else away from this explainer today, let it be this. Maintain meticulous, contemporaneous project records from day one. Having solid records is your absolute best shield against ever needing a global claim in the first place. Which leaves us with a really provocative question to wrap things up. As our project management technology radically evolves, I'm talking about the rise of building information modeling, 4D scheduling, and AI-powered delay analysis software that can basically track every single project variable in real time. Will the impossibility of linking causes just disappear entirely? Could technology eventually render the global claim completely extinct? It's a fascinating thought, and it's definitely something the entire construction industry is going to be watching very closely. Thank you so much for joining me on this deep dive, and I hope this explainer brought some much-needed clarity to the absolute chaos of global claims. Welcome.